My name is Chiara Giorgetti. I'm the co-chair of the Interest Group on International Courts and Tribunals. It's really an honor and a privilege to have today Judge Buergenthal as our guest. He is a Lovinger Professor of Comparative Law and Jurisprudence. I'm sorry if I mispronounced.
No, perfect. I don't know how to pronounce it either.
Judge Buergenthal has a JD from New York University and a master's and a doctorate from Harvard, as well as 6 honorary doctorates. And upon his many professional achievements, he was a judge at the International Court of Justice in The Hague, was a judge and the president of the Inter-American Court of Human Rights. Thank you. He was the president of the Administrative Tribunal of the Inter-American Development Bank, and he sits as an arbitrator and president now of several arbitral tribunals. His long academic career includes service as dean of the Washington College of Law at American University, and he had endowed professorships at the University of Texas and Emory University, and he is now at George Washington Law School. He's the author or co-author of more than a dozen books, including a widely read autobiography. He serves as the editorial boards of various legal journals, including the American Journal of International Law. And Judge Buergenthal, as everyone knows, is also one of the world's leading international human rights experts. He was also a member of the UN Human Rights Committee and the UN Truth Commission for El Salvador. Judge Buergenthal also served as honorary president of the American Society of International Law from 2001 to 2009. Today he has accepted to be here for a question and answer for a Q&A session. And of course, because he's sitting as arbitrator in several ICTIG proceedings, he will not take questions on arbitral matters. The event today is organized by the ASIL IG International Courts and Tribunal, which, as I previously said, I have the honor to chair and co-chair with Brooks Daly, who is now the acting Secretary General of the Permanent Court of Arbitration. Our IG focuses on the work of the many existing and proposed international judicial and arbitral bodies, and its aim is really to monitor and provide information and commentary on the work of all international courts and tribunals. Before we start, I would like to thank our host, the American Society of International Law, and its staff. The American Society is really the leading society for international law, with more than 4,000 members among academic, professional, and government lawyers. One of the main events the ASIL organizes is the annual meeting, which has really become one of the not-to-be-missed events for international lawyers. I have the privilege to serve as a co-chair of the organizing committee together with Simi Payne of the Rutgers University and Harlan Cohen of the University of Georgia School of Law. This year we have a fantastic program, and the conference is packed with interesting panels, including, especially for this audience, panels on the preparation of cases in international tribunals, fact findings in international disputes, ethics for advocates, and several human rights panels, including issues of the Arab Spring. The annual meeting is going to be held here in DC between March 28th and the 31st, and please go to the ASIL website to have more information and to register. Now, I would like to take the advantage of the moderator to start. And
Should I start?
Yes. Well, first of all, thank you again very much, Professor and Judge Buergenthal, for coming here today and being with us. I know this is going to be a very interesting session, and the number of you present today just shows this. I would like to start out with asking you a general question, to comment on, as you acted in many judicial bodies as judge, and I was wondering if you could tell us a bit more how you approach your judicial function, how you look into the decision that you're going to take, and how you how decisions are made in courts in general, and if it's different from the different systems, if you approach the question differently from the different systems.
Well, first of all, thanks very much for the lovely introduction. It's good to be here again and to see so many of you. I decided to stand up because otherwise I couldn't see everybody and you couldn't see me, so this is much easier. But as Chiara pointed out, I'm not going to give any speech. I just want questions from you because all of you have a background in this area and there are probably things you wanted to ask and never had a chance to ask, so here I am. You can ask, and this is the first question. Well, there was a big difference, for example, in serving on the Inter-American Court of Human Rights and serving on the ICJ, because on the Inter-American Court of Human Rights, it was established in 1979, and I was with the first group of 7 judges. So we all felt like John Marshall's establishing everything from the beginning, from numbers of decisions and everything else. And it was also a very difficult period in the region because there were most of the countries that had actually ratified the convention, many of them were dictatorial regimes or military dictatorships and really had no great intention of complying and believed that they would never be asked to comply, and suddenly there was a court. And so this was a very sort of delicate operation, and we did a lot of judicial policy consideration, the group of 7. Eventually, now the court is doing great, wonderful work, and there are a lot of cases decided, but in my day, initially it was a struggle just to get cases. They came. The difference of going from there to the ICJ, with all the tradition that goes back to the Permanent Court of International Justice and all the formalism and the excellency every which way you turn was quite a change. And of course, the situation was very difficult because when you're on the ICJ, you sort of have the feeling that the world is looking at you. In San Jose, Costa Rica, that we wanted to have at least somebody look at us, and it certainly wasn't the world looking at us. In terms of my sort of general philosophy, you may have noticed that I very seldom dissented or wrote separate opinions. I always felt, neither on the ICJ nor on the Inter-American Court of Human Rights, because I think if one serves on an international court, it's very important that one thinks of the legitimacy of the court, which is still an issue. And so the more separate opinions you have, the more dissenting opinions you have, you, in my view at least, weaken the decisions that are rendered. In terms of approaching, I must say I always approached it very naively, just looking at the facts and then deciding how I would decide it. And of course looking at, and only then did I start looking at precedent and what was being presented. So I never had this grand vision about the process I was involved in. And in the ICJ, there are probably more questions, because the way the ICJ operates, it's very different from the Inter-American Court, with 7 judges, with 15 judges. In the Inter-American Court, we would discuss a case that came in, and then one of us would write an opinion that would be discussed by the group, and that was it. In the ICJ, it's a much more complicated process, and I'll be glad to talk about it if somebody's interested, how we go about deciding cases, which is quite unique.
Thank you very much, Lecturer.
Well, I'll ask a quick a follow-up on that. Are there specific elements of the process from either court that you think the other would benefit from? Importing, elements of the process or the judicial process from the Inter-American Court to the ICTIG or vice versa?
Well, thank you. When I first came to the ICJ, I sort of missed the judicial policy discussion of the cases we had to decide. Because in the ICJ, after you have oral hearings, and all of us go back to our offices or chambers and write a note. There's really very little prior discussion. And once you've written your note, then there's a discussion of your note, but never sort of talking about where is the place of this case in the greatest, in general international law, in the political complexities that the issues of the case raise. It's very seldom that it's discussed. Whereas in the Inter-American Court, we discussed it quite a lot, but of course it's a different court, and given the delicate situation we were in the Inter-American Court, it was a very different approach. But I missed it because I thought there's more to a case than just the law and the notes. And I thought that the notes that we write in the International Court of Justice sort of have a tendency to prevent a really extensive discussion of the case. We focus on individual legal issues, but not of the case in its entirety. And I missed that. Or maybe I should say something about how the International Court of Justice operates in terms of the process. After oral hearings in the case, there's a very brief meeting of the judges just to discuss. The president presents a list of the issues in the case, and then we just go back to our chambers, and for the next 2 or 3 weeks, each of us writes a separate opinion in the case, and those can be 20 pages, 30 pages, 40 pages, and if you have ad hoc judges, they're 150 pages. And then the result is translated, distributed to other judges, and everybody reads other opinions that have been written. And then we have our first initial debate, basically on the notes. And after that is taking place, a drafting committee is elected. The drafting committee then goes back and prepares really a first draft. After the initial draft is prepared by the drafting committee, we have a chance to propose amendments, and then there's another deliberation where the draft is discussed. The drafting committee goes back, prepares a final draft, which is then discussed and voted on. And I don't know any court in the world that has this approach. And it's very strange. To this day, I don't know whether I like it or not. It has a great advantage because you know that every judge has worked on the case. And it was much stronger in my day because when I came to the court, we didn't have any law clerks. Now there are more law clerks. We now the court finally has one permanent law clerk. But the fact that you have 15 judges and everybody has read and worked on the case and written an opinion, that strengthens the analysis. And after all, it's very important to get everybody's view. In other courts, sometimes you sort of get a reaction and a vote without every judge having really immersed himself or herself in the material. That is not true in the ICJ, and that's important. The other side of this coin is the fact that if the majority goes the other way from your individual note or draft, you've got a perfect separate opinion or dissenting opinion. So it encourages, in a sense, the writing of separate opinions. And that's something, as you heard me say a minute ago, I don't think is always very useful.
My name is Peter Ehrenhaft. I was a law clerk at the Supreme Court during the period of Earl Warren. And one of the things that Warren used to do was walk around and try and garner support for views that he had, and it was a pretty collegial kind of an institution at the time. Before the publication of the Brethren, which then converted the court into 9 chambers that only communicate by writing and screenwriting at that, and apparently that kind of system still prevails today, even though as far as the public sees, it still looks like there are 2 determined blocks that somehow caucus and come up with a position, which I don't think in fact is the case. I think that it remains sort of fragmented 9 chambers. But there is a lot of interchange on the opinion drafting, and I just wondered whether the way that you described the ICJ, whether there was any effort by judges to lobby other judges or to go around or to have any kind of a non-official record of communication between the judges.
Well, the interesting thing is that before we've written our note, there was almost none. It's sort of like being in high school and covering up to submit. After the notes are in, and you know how everybody has come out, and there has been a deliberation, then you have more discussion, because you suddenly see that certain people have similar views on the subject. And then depending upon the case and depending on particular judges, there is more discussion. But there really isn't very much of lobbying. The only time I've really been seriously lobbied was by an ad hoc judge. But there are discussions going on. But again, not as much as one would like. Most of the discussion is then limited to the deliberations themselves. And of course, the deliberative process goes on for about 4 weeks. Given the different drafts, different deliberations. So there isn't very much of an interchange. That's also a problem.
I'm wondering if I could you said that the ICJ is really unique in how it approaches deliberation. Can you say something on how it was done at the Inter-American Court? And was it more collegial? And is the ICJ system taken from the PCIJ?
I really don't know where it came from. The last question you asked, I don't know. They had so few cases that they probably needed to deliberate a long period of time in order to have something to do. But I don't know. In the Inter-American Court, when they after the oral hearing, we would have a discussion on the case. Sometimes maybe 1 or 2 days discussion, and then one or 2 people would be asked to prepare a preliminary draft, usually different parts. That draft would come back, we would discuss it again, and then there would be changes proposed, but then at the same time there would be a sort of grammar or style committee appointed to review the style. And usually the Colombian judge was part of the style committee because Colombian Spanish is supposed to be better than everybody else's Spanish. And then when the style came in, and often, of course, the style changes were not only stylistic changes, there would be further discussion. And it was with 7 judges. It's so much easier.
2 little questions. One, if you're reading 14 other notes from your colleagues, are you ever convinced by, or are the others ever convinced by a note which seems so wonderful and enlightens you with things that you never thought about, that you would change your opinion from your note? And how does the process of persuading others, is there a space to persuade others from the discussion of the notes or the consideration of the notes?
Let me answer that first.
Okay.
Actually, it's surprising that when you hear, because after you've written your separate opinion and then you have the deliberations, the judge, who is the youngest, states his or her opinion, and then it goes around. And you find, not that often, but quite frequently, another judge will say, I've read Judge's so-and-so note and heard what he said now, and he's right. So that happens not that often, but also it may not happen with regard to everything the judge said in his initial note, but certain parts. So there's a lot of change. The deliberative process leads to change of opinions. That happens quite a lot.
And the second question, why in the Inter-American Court does the judge who writes the opinion never sign it? That you never know who wrote the opinion.
I'll tell you my well, you don't get it in the international court either, of course.
You do in the Supreme Court.
Yeah. We would have loved to be able to sign it, but given where the region and the time in which we were writing our opinions, it was felt that we shouldn't do it, because there would be possibly attempts to delegitimate certain opinions because X or Y had written it. And as a matter of fact, you may have noticed that even though there were some English speakers, Anglophones on the court, not many, 1, 2, with the exception of one very early decision, this official language, authentic language was always Spanish. Because if it had said English, it would have been clear who had written it, and we wanted to avoid that.
Yes, hi. I have a question on, not arbitration,
Oh,
because I know, although that's what I came for, but
Sorry.
but that's okay. ICJ is fine too. Well, I'm an international lawyer, so we're versatile, right? That's what we're supposed
It's
to
enough to talk about in the internet, but international.
How do you address the challenges of compliance and the enforcement of judgments? In other words, against states, the ICJ. Do you have any examples of when you were, working and how you address that? And it's always an issue, you see, because when you're enforcing, and you're seeking compliance among states, it's not always that easy. So I'm just wondering how the judges grapple with that, if at all. Because I remember a while ago, remember the Nicaragua case,
Everybody remembers.
That's right. So such examples, that's, yeah.
But I should tell you, first of all, that there are very few non-compliance cases. The issue where compliance might come into a big problem, we spend an inordinate amount of time on the court dealing with jurisdictional issues. But since states are not required to accept the court's jurisdiction, once they've accepted the court's jurisdiction, they've made a political decision that they will comply. And there are certain political costs, also depending on the state you are, if you don't comply. So I think altogether in the history of the court there were about 4 or 5 cases of non-compliance and then eventual compliance. On the court we haven't worried about it. We felt that wasn't our job. So that issue just didn't arise. What we were very careful about was to make sure that we decided the jurisdictional issue very strictly in order to be not to be accused that we just want to bring these cases in and we disregard what the states wanted us to decide. So it wasn't a big issue. But jurisdiction is a continuous issue. Almost every case there's a challenge to the court's jurisdiction by one party or the other, and consequently you waste a lot of time because if you have a separate argument on jurisdiction, you probably lose a year and a half to 2 years, and then further proceedings another 2 years, and then the court is accused of not working hard enough.
I am Surya Subedi, Professor of International Law at the University of Leeds in the UK, and currently a visiting professor at the American University Washington College of Law. There's one thing has been intriguing me for some time. How are the presidents and vice presidents of the International Court of Justice elected, and what role do they play in the decision-making process? Is on merit or on rota basis, on the basis of a geographical representation, which is the case in many organizations within the United Nations system? Thank you.
Thank you. Now, first of all, the judges elect the president and vice president. There is well, let me put it another way. The work of the president, let me start with it. The work of the president particularly is a very difficult job on the ICJ, because the president is not only the president and runs the deliberations, but is also always a ex officio member of the drafting committee. He's also a high-rank diplomat, because the court has precedent in the diplomatic corps. So all invitations, the president goes to all of these things. New ambassadors come in, they also present their credentials or at least greet the president. So it's more than a full-time job. So you have to have somebody who's healthy. But the main consideration during my time was to elect somebody in whom we had confidence that that person could handle the president's job and also handle and understand the role that he played or she played in as an ex officio member of the drafting committee, which played a very important role. And the president also plays a very important role during the discussion of the notes. And at the end of the discussion, the president summarizes the discussion and the conclusions. And it's a pretty skillful, important skill to have. And then there's further discussion on whether the president summarized it properly or not. Of course, with 15 lawyers, you'd have to get that. So the people we elect as presidents are usually people that enjoy the respect of all of the judges, or most of the judges. Of course, sometimes there's competition, and sometimes strong competition, fighting over the position. Two people want it, and you have a problem. There isn't any official regional concern. And there's been some criticism, both inside the court and out, that during one period we seem to have presidents who all came from the 5 permanent members. And that there has been criticism of that. And that is there in terms of what is in our minds, what is in the minds of the judges. The elections for judges and for president, vice president will be held in the next few days. It'll be interesting to see who comes out. The vice president's role, unfortunately, is not as important as it should be. The vice president really should be, and it depends on the president. If the president wants to use the vice president, there's a lot for the vice president to do. But strangely enough, the vice presidents hardly ever get anything to do from the president, which I think is bad. And so the president has all of this work, and the vice president is just there and sits next to the president, and that's, for the most part, all he does. But that depends on what the president wants to do.
My name is Sarah Boone. I'm a Georgetown law student. I was wondering, to what extent do the judges' nationalities and legal backgrounds and traditions influence their decisions and opinions on cases?
You'd be surprised how little. Let me explain that. Obviously, we all come back from very different cultural backgrounds. With the usual baggage, it's true of the US Supreme Court as well. But at the same time, we're all international lawyers. And what students often don't realize when we teach international law in law school, we teach one little course in international law, and it's really an entire legal system. And the judges are all familiar with the entire legal system. So, and in the discussion of the cases, the focus is on international law. And you, for example, one of our judges who is now leaving the court, Judge Karoma from Sierra Leone, had studied in Sierra Leone, got a law degree in Moscow, then got a law degree in London. And you have similar backgrounds. So there are very few judges who come exclusively from a very narrow environment. There are certain sort of cultural things that come in terms of interaction between judges. In some systems, how you speak and how you make your argument. And I think your question is also, you also ask how are the judges independent in terms of their own, that's probably what you also want to know. The important thing to remember is that the court consists of 15 judges. The UN consists of, what is it, 192 or more?
93.
93? It's very rare for most of the judges on the court to ever have a case involving their own country. So that issue doesn't often arise. Some of us, for example, during my time, there were 3 cases from the US. It's very uncomfortable. But in most cases it isn't. There are on some of the cases that come, you can see some regional attitudes. Because the court usually has 2 judges from the different regions in the world. So that has some impact. Also has an impact in terms of instructing the other judges of what the problems are in the region. So on the whole, I never had the feeling that you had this thing that somebody was out there just representing his country. I didn't have that. On that score, I should say something it's sort of my hobby horse. What has been happening on the court for all the years is that when a case comes in from your own country, the national judge does not have to recuse himself and may not recuse himself. And if there is no judge on the court from the party that has the case before the court, that state can appoint an ad hoc judge. I think that's terrible. I think the time has come to do what one would do in a good domestic court. And I must say, I would have felt wonderful not to sit on cases involving the United States, because it's uncomfortable, if nothing else. And the ad hoc judges, the attitude towards the ad hoc judges is always one, the initial, we sort of feel them out when they speak. How are they going to be? Are they going to just be advocates for the country that named them or not? Many of them aren't, some are. But so I think that system should be changed.
Hi, I'm Ellie Page from the Public International Law and Policy Group. I was wondering if you could say anything about the evolution of the docket during the time that you served on the court, sort of trends you might have noticed in the number of cases, type of cases, where they're coming from.
Well, first of all, what is so interesting is that with the end of the Cold War, cases started coming to the court. And I think many states assumed during the Cold War period that there would be problems in terms of fairness or objectivity because of the ideological divide in the world. And suddenly cases started to come. For a while, in one of my sort of year or two, I had the feeling we were at the African Supreme Court. There were quite a number of cases coming from Africa. And I learned a tremendous amount of colonial history in the process, because most of the cases dealt with maritime and territorial delimitation issues, which are really related to the colonial past of these countries. That has changed, and there are a number of cases involving Western countries, cases Italy, Germany, Liechtenstein, all of those, and also a number of Latin American cases, and increasing number of cases from Asia, which was sort of rare in the past. So it's quite wide and open, and more cases are coming. And I think the court, in my opinion, will need much more help in terms of law clerks. Because with each of these cases, when we just talked about the colonial history, you get your briefs that maybe the initial ones will be 300 or 400 pages long, and then you get annexes with the entire history of the entire colonial history, and you can't possibly read that. And my thing was always I would ask my law clerks to read it, and I knew that he would. My last law clerk is here, and I knew he wouldn't be able to read it. So I would ask him to fix something out that he thought was relevant. So I think if we had more help on the court, we probably would be doing a much better job and faster job in deciding cases. Also, the court would need more help in terms of getting out cases, because right now it's very difficult for the court to consider more than one case at a time because of translation problems and interpretation problems. If we had more resources, I keep saying we, but I'm no longer we. If there were more resources, it would help immensely.
Hi, I'm a professor at NC University in Korea. I'm visiting at Georgetown right now. My name is Louis Kim. Just kind of following up on the previous question before, I was wondering, what do you think about, or was there any type of kind of tension or interaction regarding the civil law, common law side of things, regarding that from the judges and so forth?
You know, that is an issue that when I first went to the Inter-American Court, there were just two of us from the common law system, and I thought this would be a problem. And I learned very early that if you have good lawyers for one system and the other, both of them, that is not an issue. It only becomes an issue when you start talking theory rather than facts. And if you say, now we do it this way and we do it, if you get into this problem, you'll never get out of it. But if you focus on the facts and how do you decide this case under international law, under the convention, the issue doesn't come up. You will see it sometimes in terms of how somebody intellectually reaches the conclusion. But it's not and it was on the ICJ the same way. Not really a serious problem at all. I would have thought when I first became a judge that it would be. And where it mattered was really on the quality of the judge. If you're a really good lawyer, it doesn't make a difference. On the Inter-American Court case that I always remember, we had one case, and one of the judges kept saying, well, this is a general principle of law. It was a Latin American country. And I'd never heard of it. But I didn't dare say anything and then one of the other judges raised his hand and he said, well, why do you think it's a general principle? Oh, it's in the civil code of my country. So you have to watch those types. I don't want to name the country, that's fine.
My name is Luke Peterson. I'm a legal journalist, and first of all, I want to thank you for doing this. I think it's great, and it's wonderful to hear all your responses. And it's also nice to have an event where you just do questions and answers, because as is evidence, people have a lot of questions. Mine deals with arbitration.
I'm not going to answer that.
Well, I just wondered if you had been on the record on this policy issue related to arbitration. Is that something that you would want to discuss either? I didn't want to ask you any substantive legal questions or about past cases, but I was just interested in the arbitrator counsel issue, which you had discussed publicly a few years ago.
Well, I had discussed it a few years ago, also in the context of discussing whether or not ad hoc judges and national judges should recuse themselves. So maybe I can make an exception, but I don't want any.
Well, I was just wondering if your position is more or less the same as it was in 2006, and maybe some people are not familiar with what your position was. So please tell us what you feel comfortable telling us. Thank you.
Well, in this talk, which was addressed to a group of arbitrators in Geneva, I argued what I told you about my attitude with regard to ad hoc judges and national judges. And then I also took the position that in so many arbitrations today, we have arbitrators who serve as arbitrators one moment and as counsel another moment. And I thought that raised some very serious due process or fairness issues. I still believe it. There have been many arguments told why it has to be that way. I'm not persuaded. One of them is that there are not enough good people who could do one thing or the other. I just don't believe that. But it's very important because there are all kinds, if you've handled arbitration cases, there are all kinds of problems that arise where if you're sitting on a case as an arbitrator and also have another case as counsel, there are all kinds of opportunities that arise, and I just don't think it should be done. And I won't take any others.
Thank you very much.
Hello, I'm Jennifer Hillman, and I recently stepped down after serving on the appellate body of the World Trade Organization, which in some eyes would be an international court, where we suffer, if you will, under the requirement that our opinions must be issued within 90 days of the date on which the appeal is filed and must be issued in 3 languages during that same 90-day period of time. Which has led us to struggle mightily to figure out what steps one can take in order to make it more possible to fit everything within that 90 days. And I'm curious whether there were thoughts at the ICJ of what can be done within an international court system to try to make the cases go along at a faster pace. I mean, whether you considered any particular procedural steps or other things to try to shorten the time frame that it takes to finish a case.
We always talked about it. But you have to keep in mind that many of the cases that have taken such a long time take a long time because the parties delayed the jurisdictional argument. In one of the cases, I think it involved the United States and Mexico, both parties agreed that the whole thing would be done in 3 months, and it was. So if the parties are willing, at least in the process of the ICJ, if the parties are willing to do everything in a certain time frame, then the court can proceed quite fast. The problem we have, however, and we've thought about it, is that, for example, one thing that came up was to split the court internally into chambers, not official chambers which the court has, but to say 7 judges deal with this case and several judges with the other case, so we would at least be able to bring out 2 cases. It raised a lot of issues because which case would go to which group of judges? How would you determine that issue? Even a suggestion was made we should really enlarge the court, have more judges and then operates in some ways the way the European Court of Human Rights operates. But nobody was willing to talk about the possibility of changing the statute because of the fear that if you go to the General Assembly and want to change the statute, there'll be a lot of other changes you don't want. I think I would say that in order for you to bring it out in 3 months, you probably have many more resources than the ICJ has. But it seems to be difficult. I must say I'm not very familiar with how you decide your cases, but that seems to be pretty... and this includes both the argument and the...
Probably 2 or 3 days of an oral hearing. Pretty lengthy briefs. I mean, 200, 300, 400-page briefs. And for us, I mean, as the judges, you turn in your opinion in 60 days because the translator is going to need at least 30. So, you just work long and hard. But
I'm glad I was on the ICJ instead. No, I have difficulty giving you any answer that will be helpful.
You had a brilliant idea.
No. You never expect a judge to have a brilliant idea.
I wonder if I could follow up on that. If I remember correctly.
On the brilliant judges.
Yeah, for example. But if I remember correctly, about a decade ago or so, there was a practice directions that were issued by the ICJ in directing the parties to shorten their pleadings. Has this worked? Has this expedite proceedings? Have the parties respected that?
Not really. I mean, some you see, but it hasn't really made much of a difference. Where the practice directions have been interesting is, again, going back to my hobby horse. And when I came to the ICJ, you had lawyers who were counsel in a case also serve as ad hoc judges in other cases. And they would have an office in the court. About 2 years into my being on the court, in a committee chaired by Judge Higgins, we changed it. And so now you can no longer be a counsel in a case and be an ad hoc judge in another case. It created tremendous complications. I don't know why they never understood it, because the ad hoc judge would sit at the table at lunch with the judges when you were discussing some of these cases that had some relation often to the cases that individual may have had as counsel. So there is some compliance with these directives, but there is also another. Whenever one judge will say, we need to really enforce this directive, the briefs are too long, you will get another judge to say, well, remember, you're dealing with sovereign states. You'll never hear this from the academics. You'll hear it from the former legal advisors and others. And that makes it difficult. But ideally, you really, one should do it. It'll take a president who is ruthless, and in his last year as president.
My name is Hillman Lee, and I'm an attorney at
Could you speak up?
My name is Hyunjung Lee. I'm an attorney at the Inter-American Development Bank. I wanted to go back a little bit on your comments on the deliberation process at ICJ. If you missed the process of the in-group discussion that you experienced in the Inter-American Court, did you ever propose changing the procedure on how the ICJ deliberated? Was that ever a question or possible at all?
I wouldn't have dared to propose a change. You know, when you come in as the youngest judge in this august body, you don't propose it. Every so often we would talk at lunch when many of us would get together about maybe sort of changing these opinions in terms of making them shorter and focusing only on certain issues that were particularly difficult. But it never happened. This is what I meant also in terms of judicial policy making. It's a court where it's very difficult to make changes. Sometimes it's very good, and on some of these issues, it should be possible to have shorter notes and maybe ask some people to work on some notes and others on other notes, and might change the discussion. It's never happened. Maybe since I've left, they might. And when you come in as a new judge and you propose something, and somebody will say, "Oh, we've discussed it years ago."
Nathan Dunford. I'm a law student at Arizona State University, Sandra Day O'Connor College of Law, a little far from home. This is a general question. I like asking it of people that have way more experience and knowledge than I do. But over your career, is there something that you would have changed, or something you wish you knew then that you know now, that would have helped you as you interact with other lawyers, as you influence the situations around you?
For one thing, I would have loved to transfer the climate of Costa Rica to The Hague. Never worked. Well, one thing I can tell you, I was very young when I was on the Inter-American Court. Young, I was in the 40s, which to me now seems very young. And I was quite old, which now seems old to me, on the International Court. I think I would have been able to make a better contribution if I had been younger when I came to the court. In terms of energy and other things, I probably would have struggled more to try to get things changed and to fight for certain issues that I didn't. The other thing is that also, as you get older, at least in my case, one gets a little impatient, which isn't a good thing when you are on the International Court of Justice. And so I wish I'd had the same patience that I had in an Inter-American court, where you had to listen to very long Spanish speeches. If I'd had that same patience on the ICJ, it would have helped. But I really can't think of anything. Today, probably when I leave here today, something will occur to me that right now it doesn't. I'm sorry.
Good evening. My name is Mohammed Hillman. I'm a first-year student at the GW Law School, so I'm really close to home. And I have a very open-ended question. As I'm a first-year law student, and I'm very interested in international rights law issues. And so what advice would you have to law students like me who are aspiring a career in international human rights law as successful as yours? It's a very open-ended question. Maybe you could say what you wish, what opportunities you could have pursued as a law student yourself.
It's a difficult question. One thing that I found in my career is that, especially with law students, that the focus of law students often is very short-sighted, very narrow, looking to immediacy in terms of how much I'm going to earn doing this, rather than long-term in terms of working on subjects that you're really interested in. So instead of possibly going to a law firm because you're going to earn more money, doing something that you would otherwise like to do, say working in human rights, that you decide not to do. I've always been guided by the notion that I wasn't going to let myself be moved from the course that I wanted to take in human rights and international law. And I just stuck with it, regardless. And in my day, when I first started teaching, our salaries and everything else was not what they are now. To me, that was sort of the approach, and I was quite a narrow-minded approach. I wanted to focus on the thing I believed in and do it. And also the things that interested me. And I found in retrospect, for example, when I moved to The Hague, when we were packing, and my wife kept telling me to go through these papers and throw everything out, which she tends to tell me all the time. I was struck that in my application to Harvard from NYU, I said I was interested in human rights and international courts. And I'd totally forgotten that. But you had this, so there was a certain fanaticism that I followed. And then I would write about things I thought were interesting, and every so often the issues came up. So there's no rule I can give you, nothing. I was struck, for example, when I did my dissertation, I did it on lawmaking in the International Civil Litigation Organization, which probably nobody believes in terms of my background. I did it because my then professor, Louis Sohn, said to me, "Which organization do you know nothing about?" And I stupidly said the International Civil Litigation Organization. So he said, "That's what you write about." So that's why I spent 3 years writing about it. But I forgot what helped me immensely in working on this dissertation was the fact that I knew how some international organizations work, which helped me also then understand how human rights progress could be made. I would never have thought it. And when I finished the dissertation, I thought, well, nobody's going to read this because it's so highly theoretical. And it turned out, not long after that, there was a dispute between India and Pakistan relating to air law and the Chicago Convention. And my case, my book, was cited by a number of the judges. So at a very young age, I became a very important jurisconsult on that. So you can't predict these things.
Good evening, Professor. I just have a question about during your judicial career so far, what kind of qualities and what makes a good advocate appearing before an international tribunal?
What makes a good
advocate? What kind of qualities would make a good advocate appearing before an international tribunal? Thank you.
Well, what I found interesting, particularly in the ICJ, is that sometimes when I would walk into the hearing room, I would think, I know how this case is going to go. I know what the issues are, and this is the way it's going to be decided. And then invariably, one or two of the really top lawyers would stand up and suddenly affect the outcome of the case. I never believed that was possible. I don't know whether I should name names, but for example, Professor Crawford, Alan Pillay, you heard them and you said, "See, that's really right." So you have preparation, you have a real deep understanding of the practice, and of course brilliance. But preparation is of course very important. Focus on the facts and not go off on a lot of other things. And that, incidentally, this question, let me say something else. Our oral hearings sometimes go on for weeks. And it's really unnecessary, and it complicates the case too much, because if you had very good briefs, the oral argument should focus, as it does in the Supreme Court and other places, on the narrow issues before you. If that could happen at the ICJ, both the decisions that were rendered and the outcome would be so much better than it is now, when you have the same lawyers argue for days, 7 or 8 days. They divide things up, they answer somebody. It just complicates the whole discussion of the case more than is necessary. And if you had some very good lawyers arguing the case, let's say half a day on each side, that would be enough in most cases. But we go on for weeks sometimes.
I have just one more question. As the global community has changed and continues to change, the issues continue to change with it, and of course the nature of interstate disputes will also change. Do you, within that context of, you know, the multifaceted, more complex nature of the global community, do you envisage in the future the role of the ICJ, you know, changing a little bit and looking ahead? You know, what would you predict will be, you know, for instance, like you mentioned the European Court of Human Rights, for instance, with the Nuremberg trials long ago, then they started receiving individuals had local standing before the European Court of Human Rights. I'm not claiming that that would happen before the ICJ, I'm just giving that as an example. So in what area, if any, do you think that the ICJ may sort of change or adapt to the changing international law, as I envisage it will change in the future?
Thank you. I think, whether I think it's good or bad, I think sooner or later the ICJ will have to have more judges. And the structure may have to be different, that you may have to actually have two main chambers with a sort of appellate structure to the chambers. And the reason I think you need more judges is because I think more and more cases are going to come to the court. What is so interesting is when you hear some people talk, even diplomats who should know better, they say, oh, well, we'll take this dispute to The Hague. But they don't know whether it's going to the criminal court, it's The Hague. So it's, you know, 10 years ago nobody knew where The Hague was, except the Dutch. So I think it sort of the international judicial system is taken hold, will take hold even more once the International Criminal Court really begins to work, once the African Court of Human Rights begins to work. So the legitimacy of international judicial institutions will get much stronger, and that will require much more input and output by the International Court of Justice.
Just to follow up on that question, with the development of the international judicial system, do you see any changes in sovereignty and the concept of sovereignty?
Well, I thought the concept of sovereignty was dead 20 years ago. Because, you know, it's always invoked, it is something that those of us who worked in the human rights field always had to contend with, that this was sovereignty, and states never understood that if they signed a treaty, they've given up on their sovereignty to the extent of the treaty. So I don't think that is an issue as much. The issue really is, or the sort of the way of looking at it is, two states have a dispute. That dispute is not something earth-shaking. It's just a regular dispute that should be settled by negotiations. They can't settle it by negotiations because either side of it tried to settle it, the government would fall. It's so contentious, and not a major issue. So what do? You go to the court, you go to the ICJ. And that is happening more and more, because the assumption is, well, if you go to the ICJ and you lose, it takes a very different result. The government might be accused of not having had the better lawyers in the case. As a result, they always hire the most expensive lawyers anyway. But the sovereignty issue is not really a major issue. What you're going to find, incidentally, is that what we thought of when I was a student and I was starting to teach, I thought it would be important that all states accepted the jurisdiction of the ICJ. I don't think that's going to happen, at least not for a long, long time. But what is happening more and more is that states ratify treaties which contain dispute settlement mechanisms involving the ICJ. So they have a very narrow scope of what they are committing themselves to. And that's a much easier thing to do than to submit yourself to the ICJ in a very broad notion that you would have under an Article 36, for example. So I think more and more cases coming to the court under these treaties, and that is going to continue more. So many treaties are being ratified, entered into, and the court will have a lot of business under these treaties. And the sovereignty issue there doesn't arise at all, and isn't even thought of. If a country wants to enter into a bilateral treaty on some subject, or even a multilateral treaty on that narrow issue, most states will accept the jurisdiction of a court to settle a dispute. It's a much easier way to deal with it.
I wonder if I can conclude with one last question. Maybe about yesterday, the ICJ delivered its advisory opinion on IFAD, the IFAD question, and of course the IFAD.
That's the
shows
you how far away I am from it.
The advisory opinion on the administrative tribunal of the. And my question was not on the advisory opinion itself, but more on the issue of the fact that the ICJ also has an advisory opinion functions. And I was wondering whether the deliberation in those situations is very different, or is it similar? Because we've seen that the code is being used now for different advisory opinions that are very important.
Yeah. I don't think it's an interesting question. I've never thought about it, but I've never had the sense that the deliberations in the context of an advisory opinion were different from contentious decisions. It really didn't raise the issue. In the Inter-American Court, there were issues because all of us had no judicial experience, and some of us thought, well, the advisory opinion, you can really write a book about the subject. And to sort of get judges to understand that this is a judicial act, it's not just a free-for-all to write about whatever you want to write on this subject, was a difficult issue, was a problem. In the Inter-American Court, I didn't see it in the ICJ. What I should say, the difficult problem I always have with my students is to get them to understand that an advisory opinion and a contentious case is equally persuasive. And of course, neither is necessarily binding. So there's really no difference between them except for the party that is a party to the case under Article 59. So I think there's a tendency among students, for example, to look for a contentious case on the subject rather than to also look for the advisory opinion, because many times, very often, the advisory opinion will contain some very important legal conclusions that can be relevant. And of course, the lawyers appearing before the court know that, and they are cited the same way as contentious decisions.
I would like thank you very much, Dr. Buergenthal, for your generosity in coming here today and sharing with us your experience. Really, it's the brilliance of the judges. It's obvious. Thank you very much.